case. I think seven of them are on the bills that were submitted for Mr. Joe.
I think he may have signed off accidentally.
How'd I do?
Sometimes people do that when they see the YouTube thing coming up.
Yeah.
Right.
Hopefully he'll sign back on.
I apologize, Your Honor. My internet there. Sorry about that.
It's okay.
Um,
So let me ask you this. So this is, brings us pre-NRA Allstate. I would have struck this every single time. NRA Allstate kind of changed the game on these types of motions. If the world was according to Judge Hoffman, I don't think these affidavits should be allowable. But how do you distinguish this from NRA Allstate?
Well, yes, Your Honor. And to be clear, I've filed a lot fewer of these since NRA Allstate as well. I think it's just become harder on the plaintiff side on the law on that. There are separate distinguishable grounds on this one from other ones that are, filing just because she's a billing coder. That's not the reason we're filing this to strike her on this. First reason, I guess, is that Ms. DiPaolo's counter affidavits in regards to a number of the bills were late. So we served 1801 affidavits from 9 providers for Mr. Rodriguez on March the 1st, and from, I guess, 9 providers for Mr. Alvin Ogilvy on March the 1st as well. Those are laid out on page 4 of plaintiff's briefs. They didn't file the counter affidavits until May 31st, which was, 2 months later. We've got a scheduling order on file that provides, counter affidavits have to be filed within 30 days of the 1801 affidavit that they're controverting. So just as an initial matter, a number of these are not timely filed. They're not
any of them that are untimely are struck. So if they are untimely, anything's untimely is struck.
Okay. The ones that I guess that were still present then, and I may need just to revise the order then on that. So there's a number of ones we had to file supplemental ones, I think, on May 1st, and those ones are timely. So the ones from Davis Mountain Health for Mr. Rodriguez, MRI Centers of Texas. There's a supplemental one from Dr. Andrew Indrasano and one from Uptown Radiology that were served in May, and those were timely. She did at least timely respond to those ones, as well as to an MRI Centers bill for Alvin Ogilvy and an Uptown Radiology Associates bill for Mr. Ogilvy. Those ones were timely. I would still separately on those ones distinguish it from NRA Allstate. In NRA Allstate, the counterfeit was a nurse named Nurse Dickinson. She'd been as a nurse for 21 years or so. She'd had extensive billing experience in the area. She was also working as a certified auditor. And so based on a number of different credentials, it wasn't just, okay, she's a bill coder, so she can testify on these things. The court did find her qualified to offer her opinions on this. In this case, Ms. DiPaolo's CV shows she's never really worked in Texas. She works, I guess, as a billing coder in other states. She isn't a certified auditor the way that Nurse Dickinson was in the NRA Allstate case. And so it may qualify her, I guess, to give some opinions comparing reimbursement rates to reimbursement rates in other states like California and New Hampshire and Massachusetts, where she's worked in some consulting positions before. It doesn't establish her credentials to testify as to reasonable value of medical services in the Dallas-Fort Worth area at the time these services were provided. And so I guess just based on that qualification grounds, it's not quite the same qualifications. I'm not saying every coder should be struck immediately. I think we can. I don't necessarily agree with what the ruling was in NRA Allstate either, but that's what the Supreme Court ruled, and I'm not here to debate that. I'm not saying every coder needs to be struck because they're not a medical provider, but they have to establish the credentials and qualifications to talk about what qualifies them to know what reasonable value is for the services in the area. And I don't think that Ms. DiPaolo's counter affidavits do that. In addition to that, there's some issues with the methodology she uses that I think are distinguishable from the Nurse Dickinson and NRA Allstate. In NRA Allstate, Nurse Dickinson used a context for healthcare database and took, I think it was the 75th percentile of that context for healthcare database, compared it. And at least that context for healthcare database was comparing, charges to charges. I can disagree with her as to whether that's a fair value when you're saying, you know, 1 in every 4 medical charges in the Dallas-Fort Worth area are unreasonable. But at least I understood what the methodology was and was able to, you know, attack her, take depositions of her. I've, you know, had her designated on other cases, and I've had to go take depositions, and sometimes I file, you know, depending on what the testimony is and the opinion she's offering, I'll file a 702 motion if that's the case. Here, Ms. DiPaolo has a pretty different methodology. She uses this 3-pronged analysis. So she breaks the bills down into different types, where they're, you know, the professional components, the inpatient, outpatient, facility fees, durable equipment, and pharmaceuticals. Then she takes 3 different databases and takes the median of those. So even of the 3 databases she uses, I can't really tell from the counter affidavit if these databases she's using are actually comparing charges to charges the way the Context for Healthcare one that Nurse Dickinson did. It seems from some of them, it discusses allowable amounts, I think, on paragraph 11 on her exhibits A and M. It's, you know, on one of these ones on the Find a Code's national UCR, that looks like it's comparing a reimbursement rate to a charge rate, but I can't even really tell that from the counter affidavit. But it's taking 3 different sources of this data, and then it takes the median of those 3 sources. So she doesn't even use the same 3 sources and compare all of them. She just takes the middle one out of the 3. And so on each of these bills she's controverting, she's throwing out one of her 3 sources unless it's, you know, favorable to her. So she doesn't explain why, okay, even one of her own sources, if it's too high, she would throw that out. Doesn't provide any explanation for that. She talks about this using this Find a Code national UCR database, which is, I guess, one of the 3 databases she's using. And she applies like a geographic coding factor to it. But I think that this database, at least from what she writes in the counter affidavits, it's already applying its own geographic pricing factors. I'm not understanding why she has to reapply a geographic factor to something that's already being geographically factored. That's being double done, you know, being applied twice on these things. And so it's not really made clear at all, you know, why this use of the median, where she's throwing out one of her own 3 sources to do it. It's not really clear why she's applying a geographic adjustment factor, you know, potentially multiple times on this Find a Code UCR one in the cases where she uses that. On some of the bills, like for the Premier Injury Clinics and Elevate Healthcare bills, she claims that the charges should be 0 because they're not allowed when submitted with other codes, but doesn't provide any real opinion on that. And that seems to be a medical necessity type opinion, which I don't think she offered, you know, shows she's in any way qualified to offer. Saying it should be 0, it shouldn't be coded together, doesn't explain why she thinks that's the case. I'm still, you know, I understand the laws, the standard is higher or is lower for these counter affidavits after in real estate, but it still has to provide me with reasonable notice under the statute as to why the counter affiant doesn't believe that the bills are reasonable. You know, they still have to provide me sufficient information to take a deposition, to go, you know, prepare a cross-examination of this expert based off what she's telling me. And based off what's in these counter affidavits, it really doesn't clarify that well enough. And so, you know, I'm not really even able to develop an attack because I can't tell whether these databases she's using are actually using charge rate to compare charges to charges or comparing charges to reimbursements. I can't figure out why she's throwing out one of her own 3 sources. I can't figure out why, you know, a geographic factor appears to have been double applied on some of these ones. And then she's not really citing, you know, why this geographic, I guess, adjustment factor, or telling me, you know, why she's applying this methodology. And so without that guidance, I guess I don't have sufficient information to even take a deposition on it, where we could have then a separate fight on a 702 motion. And so for those reasons, we'd move to strike this counter affidavit, Your Honor.
Response?
I'll respond to the last point first, Your Honor. I think Mr. Clay underestimates himself, because the last thing I just heard for the last 10 minutes was what would be the cross-examination of her when he does take her deposition. He seems to know all the questions he needs to ask her. He clearly understands her methodology and what databases she's using. It clearly meets the standard. The fact that she's not a nurse has nothing to do with it. The Texas Supreme Court said that if you're a medical provider or not has no bearing on whether you're qualified to testify to billing, that most nurses and doctors have no idea what reasonable billing is because they're in the practice of treating patients. As far as the untimeliness, Mr. Clay left out kind of an important detail. The affidavits that he served on March 1st, he's claiming were due within 30 days based on a scheduling order that wasn't entered until April 11th. When under the statute, we have 120 days to file our counter affidavits to those that were filed at the time that suit was filed.
So Mr. Clay addressed that issue.
With a schedule order? Yes, Your Honor.
Yeah.
I mean, the parties sent a proposed scheduling order to the court on April 7th. It was signed by the court on April 11th. But at the time that we entered the proposed scheduling order, we agreed on what the terms were, and it says, I can show the court the scheduling order. Can I share my screen, Your Honor? Or not?
Yeah, give me a second. Go ahead.
Thank you, Your Honor. So this is the applicable provision of the scheduling order. And so, our deadline to serve 1801 affidavits isn't until January 15th of 2024. But it provides the defendants have 30 days from the date of the affidavit to produce each counter affidavit. They agreed to that term when we agreed to the proposed scheduling order that we submitted to the court on April 7th, and the court signed that based off their signatures on that. If they wanted to apply the statutory language, they could agree to just do it by the statute, and we didn't have to vary it. But under the statute, you're allowed to set out what the deadlines are in the scheduling order, which we did, and we filed that with the court.
Well, there's actually no language in the statute that allows a court order to change that 120 days or the designation of experts as the deadline. Those are the circumstances that are given in the statute. It doesn't give you an ability to change that or shorten it in any way. And obviously, this was a forward-looking scheduling order. We weren't agreeing to that our deadline had already passed to affidavits that had been filed at that, at the beginning stages of the litigation. And obviously we had a good faith belief that's when those affidavits were due 120 days. That's when they were served. And there's no way the plaintiffs are unjustly surprised or prejudiced. Like you said, the deadline for medical affidavits is for the plaintiff is January 15th, 2024. Their expert deadline is February 14th, 2024. These have been exchanged in the early stages of discovery, and there's absolutely no prejudice or surprise to plaintiff.
So give me the timeline again. So when was the scheduling order entered? April 11th, I think you said. And when were the counter affidavits filed, or the original affidavits filed?
The original affidavit. Go ahead, counsel.
March 1st, Your Honor.
Okay, so the original, and you filed your counter affidavits when?
120 days after that date, May 31st.
Oh, so you filed them more than 30 days after the scheduling order was entered.
Correct.
Okay. So, and that's the case for all of them, all of the untimely ones, all the ones that claims to be untimely.
Correct, Your Honor.
Okay. I don't see how you can think that. I guess I could see the argument of like, if he tried to say it was untimely because, you entered them they filed them on March 1st, and then you responded with counter affidavits on April 15th. But if it's more than 30 days, I don't see how you can think that. Whoa, I don't know what that was. What happened there? But I don't know how you can really argue that if it was more than 30 days since the scheduling order, you would have known that it was at least, you know what I mean? It's already been on file. So I agree with Mr. Clay that those would be untimely. You're not looking backwards because you were more than 30 days after the scheduling order. So those are untimely, those are struck. So, and for the remainder, one of the arguments he made, I thought was fairly effective, was that they didn't have experience in Texas with billing rates. What is your response to that?
Your Honor, the databases they use are nationwide and honed down to a specific jurisdiction. I'm sure Mr. Clay wouldn't argue that one of his transportation experts shouldn't testify in Texas because he's never worked in Texas before.
But you have to know what the reasonable rates are in Dallas County or, King County or Bexar County or whatever. It
And-
does
and-
require.
And Your Honor, that's what the databases come in. They provide you the geographic.
But
reasonable
the
rates.
expert also has to be knowledgeable about it, right? I mean, I mean, in Ray Allstate, who knows what it means at this point, but if that's still the case, but the law had always been like a doctor from, let's say Laredo, who's never practiced in Dallas, isn't going to be able to testify about reasonable rates in Dallas County. I don't know why a billing expert who's not familiar with the unless there's case law that says you can have an expert, let's say in Nome, Alaska, but as long as they have this database, they can testify anywhere in Texas. Are there any cases that say that kind of eliminated this requirement that you have to have familiarity with the locale?
Yes, Your Honor. The Gunn versus McCoy case. I mean, that one held insurance subrogation agents are qualified to use their databases to create affidavits regarding the reasonableness and necessity of plaintiff's medical expenses. And they necessarily are not going to be in the same locale as where the plaintiff was treated. And if this was a case, if we had any lawsuit outside of, essentially the 5 major cities in Texas, we would never have the ability to file a counter affidavit because there's not going to be someone that works in those areas.
I'm not saying they have to work in those areas, but they have to be familiar with the rates in those areas, right? I mean, that's the issue. You could have somebody in Laredo testify about Dallas rates if they were familiar with the area, but if at least the law had always been prior to in Ray Allstate, my understanding is you had to have familiarity with the locale.
And that's how they get the familiar with locales, the databases that provide what the actual charges are around the county.
So I've read that case in the past. I don't remember that topic. So share screen where it says that that's no longer a requirement from Gunn.
Your Honor.
Maybe it does say that. I'm not. This is all a brave new world. You pulling it up? Where are you looking for it?
And while we're searching on it, just to address Gunn versus McCoy, I mean, my understanding, I think, of Gunn was that it was a case in which a plaintiff's lawyer was suing a medical provider to get the bill reduced, after something, and they, it wasn't a counter affidavit issue. It was actually like a 702 motion to strike an expert, but by a plaintiff that they said, okay, and they had brought in their own subrogation agent to say that the bills should be less than they were to get this reduction. And that was part of what informed in Ray Allstate was that, the court saying, okay, well, we ruled in Gunn versus McCoy that this person could testify. So goose gander. But I'm happy to read I guess what it is on whether an outside person can do that. I'm not familiar with that. So
it is talking about the necessity of medical expenses. And it talks in here, this section about insurance companies are at the center of what the allowable and reasonable costs are. And that it does not require a medical provider or medical provider's record custodian to be the person testifying as to the reasonableness of the expenses.
Here, so go ahead, stop. This seems to be where it is. Okay. go down. Can you move it down a little more? Okay, go back up. Go back up, Mr. Rick. Mr. Clay, what is your response to that?
I'd like to see the full thing. I don't know how much gun was discussed in the response. I mean, my understanding of Gunn versus McCoy, it was a different kind of factual scenario. It was actually a case that had been brought by a plaintiff to reduce the medical bills. I'm not sure where the McCoy affiant for the plaintiff in that case was located. And you know, Gunn versus McCoy did inform the court's decision in re Allstate, because they said basically Goose Gander, the plaintiff in that case, had been allowed to use this billing or subrogation agent to controvert the or to say that the bill should be less than what it was, and so that was subsequently applied in the real estate case. I'm not sure where in that I didn't see, at least what we were reading there, where it said that the McCoy was from somewhere else and that he was using a national database, and that was an appropriate way. I'd have to read, I guess, the full opinion, a little bit more detail on it. I mean, my thought on it is that, you know, she has to show some familiarity with what the billing practices are. You can't just say, okay, well, I know that there's a database, therefore I'm going to, you know, get into this third-party collateral source payment data on the internet, you know, which anyone could go look up. It wouldn't be admissible evidence over a hearsay rule otherwise, but we've got an expert here to talk about it and say, oh, because, you know, Blue Cross Blue Shield somewhere, you know, I've never been, might take this rate on it, then it, I guess, reflects a
So
reasonable.
guys, let me just short circuit this. So for all the untimely affidavits, the ones that I've determined to be untimely, those are all struck. So hopefully, I'm sure you guys can work all that out. For these other affidavits, I really think that I want something briefed on, because I don't want to just do this on the fly. I want you to set a new hearing, Mr. Clay, if you want to, if you feel like you can prevail here. If you could go ahead and brief the issue. Is it required that you have knowledge of the locality, or is a database enough? The thing he cited in Gunn seemed kind of persuasive for his side, but I agree, I don't know it's dispositive. And so if you could go ahead and research that issue alone, and if you feel that it's necessary to have another hearing because you feel you have a good enough argument on it, let's bring it. Otherwise, I'm going to deny the motion to strike on those. Does that make sense?
It does, Your Honor.
Well, go ahead and prepare an order for me on this. This was heard on September 18, 2023. Make sure you share it with Mr. Uig and get it to me by this Thursday, okay?
Your Honor.
Anything else, guys?
No, Your Honor.
All right. Thank you so much, guys. You have a great rest of your day.
Thank you.
Bella, have you had a chance to talk to Miss Sanji or anyone from her side?
Your Honor, we've emailed back and forth this morning, but we haven't been on the phone having a discussion.
Because I understand that she may be ill, with some of the other lawyers. There she is.
I do understand that. I don't understand the extent. Ms. Sanji might need.
Yeah, I don't know either. Hello, Ms. Sanji. Are you at the office?
I am. because all of my stuff was here and I didn't know what you would be, how this would be handled. So I'm in my office behind a closed door with a mask on.
Okay. So tell me, I can kick everyone out if, let me take this off